Good morning and welcome to today's virtual conference on police officer decertification hosted by the Civilian Oversight Commission. My name is Danielle Butler-Vappy and I'm the Interim Executive Director for the Commission. Today we're discussing the process and circumstances when the Commission on Peace Officer Standards and Training, which is commonly known as POST, can revoke certifications for peace officers so that individuals will be disqualified from peace officer employment in California. We have a great panel of speakers lined up to explain the process and answer your questions. You'll hear from Manuel Alvarez Jr., who's the Executive Director of California's Commission on Peace Officer Standards and Training, along with his Assistant Executive Director, Anna Marie Del Mangano. Next, we'll hear from Los Angeles County Sheriff's Department, Ernie Arce, and a few other folks from the Sheriff's Department who will help out in that presentation. Then you'll hear from Los Angeles County District Attorney's Office Director of Prosecution Support, Diana Turan, and LA County Inspector General Max Huntsman. Lastly, Mara Wachen from the American Civil Liberties Union. And finally, your moderator will be the Commission Chair, Sean Kennedy. Thank you all for joining us today, and we invite your feedback on our conferences. You can respond to the survey that will be at the end of this WebEx session, or email us at cocnotify@coc.lacounty.gov. And now I'll turn it over to Chair Kennedy.
Thank you, Danielle, and welcome to our webinar on the Peace Officer Standards and Training post-process. My name's Sean Kennedy, and I'm the chair of the Civilian Oversight Commission. And we are really happy to have this discussion with the public today about the new law, which requires, or at least allows, decertification of law enforcement officers who have engaged in serious misconduct. And in researching today, I saw that our state, California, was really one of the last states to have a decertification process. And so I think it's important that we talk about the process for revoking the certification of peace officers so that those officers will be disqualified from, working as law enforcement officers. And we have a panel here who is going to give us all the details of the new law and how it is being implemented and what is going on in our own county, in Los Angeles County, with the Sheriff's Department. So they're going to talk about the decertification database hosted by POST and the LA Sheriff's Department's compliance with the new law, which is often called Senate Bill 2. And the panel will also discuss areas of interest to many members of the public. And some of those topics are, what's the criteria necessary to add a deputy to the Brady list? And when can a deputy be relieved of their job in accordance with the civil service rules? Because we often hear that discipline was overruled by the Civil Service Commission. And finally, when a deputy can be charged with a crime, because so often we get memos from the district attorney's office that tell us that the officer should not be charged. And so all of these topics are on the table, and our hope is that members of the public will join us in this discussion, because we have all the experts here who really can facilitate having an informed conversation that can really get to the bottom of your questions and concerns. I'm not saying that everything the panelists tell us will be pleasing, but I think it is really important for all of us to know what's going on in our community with officers who have engaged in serious misconduct, and what, if anything, we can do to stop that from continuing to occur. As the Civilian Oversight Commission continues to evaluate all these practices and policies of the Sheriff's Department with regard to SB2. We welcome community feedback. And after the speakers share their perspectives, they're each going to talk about 10 minutes each. We're going to open it up for questions. And that's, I think that's the part of the program that everyone is looking forward to. So now I'm going to turn the floor over to our speakers. Danielle has introduced them all. Speakers, I think you should feel free to give any background or context about your expertise that you think would help our audience. And we're going to begin with our friends from Post.
Thank you, Mr. Chair, and thank you, Madam Executive Director, for allowing us to speak today and giving us the opportunity. My name is Manny Alvarez. I'm the Director of the Commission on Peace Officer Standards and Training, which is a state agency. We have approximately 608 agencies, law enforcement agencies across the state that currently participate in the program, in the POST program, and therefore fall under Senate Bill 2. And then we have approximately 20 law enforcement agencies across the state that have elected not to participate in the POST program. However, they still fall under Senate Bill 2, so we are actively working with them on the implementation and the decertification, certification of their peace officers. Today, we're going to give you a very, very quick overview of the POST process for decertification and certification. We want to spend a little bit of time on what temporary suspension means, where we have authority to temporarily suspend an individual, as well as what the difference is with the full revocation. Just to give you a little bit of the state of affairs in terms of the implementation of Senate Bill 2, we really kicked into gear as of January 1 of this year. Although, as you'll see with some of the material that we're going to present to you, it really started in January of 2022. The reporting to POST started January 1 of 2023. So that's really when the work really kicked into gear for us in terms of reviewing cases and reviewing reports. As it stands today, we have just under 17,000 reports that have come in as of this week. You'll see a slide that has some numbers as of last week, but we're just under 17,000. We really didn't know how many reports we were going to receive. It was going to be an estimation on our part in the last couple of years based on what other states were doing and what we were seeing in other states. We anticipated 16,000 this year, primarily due to some retroactive reporting that's required in Senate Bill 2, which requires 3 years of retroactive reporting. So we're slightly above that. There are still some agencies that are still providing retroactive reports. Some have sent us communications saying they weren't able to send us all of their information and meet the deadline. So we still will have some additional retroactive reporting between now and the end of the year. So we'll talk a little bit about our processes, and we will also provide you some statistics across the state, and we'll also provide you some statistics specific to the LA County Sheriff's Department. To do the primary part of this presentation is my colleague, Anne-Marie Del Manayo. Anne-Marie is the Assistant Executive Director that runs the division over SB2, what we refer to as the Peace Officer Standards Accountability Division, which is called for under Senate Bill 2. Anne-Marie comes to POST with approximately just over 20 years of experience with the California Department of Consumer Affairs, where she worked on licensing programs, managed licensing programs, and led licensing programs for the Department of Consumer Affairs. So we're very appreciative that she came on board just over a year ago to help us with the transition and to lead these programs at POST. So now I will turn it over to my colleague Anne-Marie, and I'm going to move the laptop over because we're sharing a laptop.
Thank you. Good morning, members. Thank you for having us today. There's quite a few slides. I think the air conditioner just kicked on, so I apologize for the background noise. There are quite a few slides here that I know we're going to make available to everybody that's participating in the meeting today, so I'm not going to go into detail. This is essentially who falls under SB2 and the fact that now without a certification, a peace officer may not exercise the authority or duties of a peace officer without a certification. So Jennifer, next slide, please. Thank you. So as most of you know, commencing on January 1st, Post started to review these reports of serious misconduct. As Manny mentioned, we have well over 16,000 at this point. And the point to all of this is to look for these 9 acts of serious misconduct. And if they have occurred, Post is to evaluate the cases to determine if it meets the threshold of clear and convincing evidence, by which Post would be able to take some formative disciplinary action, either suspension or revocation. Next slide, thank you. So we do review quite a few cases. The officer has a right to appeal if the officer receives what's considered a notice of intent to revoke or suspend. There is an appeal process that's considered due process under the Administrative Procedures Act, and that enables the officer to stand before what we would consider our Civilian Oversight Board, Peace Officers Standards Accountability Advisory Board. The officer could then appear before the commission, and if the case moves forward to a full hearing, an evidentiary hearing, appear before an administrative law judge. Next slide. Thank you. Manny mentioned immediate temporary suspensions. So there is a provision, 13510.8 of the Penal Code, that provides the authority to the Executive Director of Post to immediately suspend a peace officer certification. And there are a few factors within which the Executive Director can make that decision. It's either an arrest or an indictment, or the officer was terminated from their agency or resigned during a pending investigation. The executive officer also considers whether the immediate temporary suspension is in the best interest of the health, safety, and welfare of the public. When we do take the immediate temporary suspension action, we refer to it as an ITS, there's a notification made to the officer, the district attorney in that county, and also the agency head, and those notifications are made in writing. The officer does have an opportunity to appeal within 15 days of the issuance of the ITS. And the appeal is reviewed by the executive director to determine whether any of the fact patterns or the information as we knew it at the time were in question and should otherwise be considered for a withdrawal of the ITS. Next slide, please. So let's talk a little bit about LASD's reporting. To date, we've received just over 1,100, almost 1,200 reports of serious misconduct. Of those, you can see here, we show how many are opened with Post, and that means that Post is in the process of evaluating those reports as cases to determine whether there is some formative action that Post should be taking. So about 13% are open with Post. 87% are still with LASD. That means there is not a completed IA. So there's an internal affairs investigation that is continuing with the agency. And we've closed a total of 59 cases. Most of those closures are cases that we would consider non-actionable, meaning they were one of the 9 acts of serious misconduct under the look back period from January 1st, 2020 to January 1st, 2023, but only 3 of those categories from the look back portion of the law are actionable, and that is dishonesty, excessive use of force that's likely to cause serious bodily injury or death, or sexual assault. So these cases didn't fall into one of those 3 categories. Next slide, please. And here we have kind of a total statistical profile of where we are today. Again, we've mentioned some of this. There's just over 5,000 cases opened with Post. We've closed 3,400. Again, most of those closed cases are what we would consider non-actionable cases. I think what's probably something that we should take note of is the average time frame to process a report. And that means to review it once it comes in from the agency to determine whether it's complete and whether we can make an assignment is just under 3 days. So the time frame to actually do the intake is very quick. Next slide. So this shows a profile of reports, not cases, and that's an important distinction. This is the allegations that come in and what the top 3 categories are for the reporting from agencies regarding the 9 acts of serious misconduct. So as you can see here, physical abuse or excessive use of force is roughly 43% of the cases we see from the law enforcement agencies, followed by demonstrating bias and abuse of power. Next slide, please. This is an example of what you will find on our certification action page under Post website. We've included a link at the bottom there so you know where to go to see this information. These are all of the actions taken by Post and what information is displayed about the officer, the actual, what led to the action, whether it's a surrender, an immediate temporary suspension, a revocation, which would be something under what we consider a Government Code 1029 disqualifier, where there was a felony conviction or a federal conviction that led to the officer being ineligible to serve as a peace officer in California. Cases that occurred prior to January 1st, 2022 would result in an officer being deemed ineligible. Anything post January 1st, 2022 would result in a revocation for what we call a Government Code 1029 violation, which is essentially felony conviction. Next slide, please. And here are several of our reference links to information, including background inquiries where agencies can submit inquiries to Post about any information that we may have on file regarding an officer that they're intending to hire. There is also the link to our bureau chief for our Professional Conduct Bureau in LA County, and that is Mike Radford, and that is the bureau chief that covers the region where LASD resides. So that completes just a short kind of overview of where we are today. And again, Manny and I will both be here to answer questions as we go through the rest of this process. I think Manny wants to add one comment before we move on. Thank you.
I know, Mr. Chair, before we hand it back to you, there's a reference to other states, I believe, by the chair. And yes, California is one of the last few states to allow for revocation of a peace officer certification. There are some distinctions that I would like to point out for California at least, and now some other states are starting to follow. So you see these large numbers of reports, 16,000 reports. The difference with California and other states is SB 2 requires reporting of a complaint, charge, or allegation. And when we talk to other states, although that seems to now be the trend, most of them are receiving reports of sustained findings of misconduct. So we obviously are getting the initial complaint, charge, or allegation within 10 days as called for under Senate Bill 2. So you see these large number of reports coming in every week, and thus the 16,000 number that we provided. That concludes our presentation. Mr. Chair and Madam Executive Director, we will stay on the line and follow your guidance.
Thank you so much to our friends from Post. And now we're going to hear from the department. Ernie, I think you're going to take the floor now. So go ahead.
Thank you, Chair Kennedy, and everyone, all our stakeholders and partners. So my name is Ernie Arce. I am Administrative Services Manager 2. I am assigned to Risk Management Bureau. That's part of the Office of Constitutional Policing. And I was part of the original 3 members that were placed in charge to handle the response to Senate Bill 2 and the new requirements by Post and the new law. We'll get to the presentation. So this is our first slide, Peace Officer Decertification. So we want to give you a rundown on the department's compliance to Senate Bill 2 as of today's date, September 7, 2023. So the team that was comprised of 3 originally, now it's grown to a team of 4, has reviewed over 57,000 retroactive records of incidents that involve 10 categories of investigations. So if you see the reverse funnel that's on your screen, the 57,000 retro reports are basically from investigations, shootings, lawsuits, claims, policy of equality violations or POEs, preventable traffic collisions, use of force incidents, custody complaints, and then service comments, which are also known as public complaints that are documented in Watch Commander Service Comment Reports, or WCSERs. And then finally, formal supervisor inquiries. When an incident requires additional information, the units have to do some inquiry information to see if there is a need for an internal investigation or unit level type investigation. To date, 19 employees have been discharged by the LA County Sheriff's Department. 158 employees have been relieved of duty with pay. And to date, 14 employees have been suspended without pay according to Civil Service Rule 18.01. Of those discharged or suspended with or without pay, Post has immediately temporarily suspended, or ITS, 14 LASD employees. 6 of our sworn employees have been convicted of felonies in a court of law and are now ineligible to possess a Post Peace Officer certificate according to Government Code 1029. To date, as Post will also corroborate, Post has not initiated any decertification process on any LASD employee. Jennifer, next slide, please. So what is the status of compliance with Senate Bill 2? On July 11, 2023, Sheriff Luna sent a letter to Post detailing the department's compliance status with Senate Bill 2. We're happy to report that LASD is in full compliance for all reporting regarding any allegations of serious misconduct for the current year of 2023. A business process was established with the team comprised of the original 3 members and other stakeholders such as County Council. We've also corroborated with OIG to remain compliant with current and any future allegations of serious misconduct that needs to be reported to Post. To date, LASD has not completed its entire review of retroactive reporting compliance. We are happy to report that we reach 100% compliance related to investigations that require a report to Post, which contains 395 allegations of serious misconduct for the years 2020, 21, and 2022. The projected completion date for the rest of the retroactive reporting that we need to take care of is targeted for December 2023. That also was included in the letter that Sheriff Luna sent to Post to express our targeted efforts to be compliant by the end of this year. Jennifer, next slide, please. So internal criminal investigations. So on-duty allegations of criminal misconduct against sworn employees, deputy sheriffs and above, are investigated by ICIB. Upon knowledge of a criminal allegation against an employee, Internal Affairs monitors the case. Upon completion of the ICIB investigation, if there's probable cause to do so, cases are presented to the DA's JCID division for filing consideration. It's important to note that prosecutors are the ones that decide whether and what to charge. Upon completion of the ICIB investigation and with a disposition, an administrative investigation begins. IAB investigators investigate the allegation of serious misconduct. They compile their findings in a report and present the case to the appropriate unit commander for disposition. We want to point out that disposition can range from no discipline to discharge or termination from the LASD. Next slide, please. So admin investigations don't have the connotation of a criminal misconduct element. However, IAB investigators do conduct their investigation on allegation of misconduct, any type, and then compile their findings in a report and also present the findings to the appropriate unit commander for disposition. We want to point out that an employee can be relieved of duty with pay upon knowledge of an allegation of serious misconduct during any time of the course or scope of the investigation. Upon the department acquiring knowledge of any felony criminal charge, an employee can be relieved of duty without pay according to Civil Service Rule 18.01. Again, disposition can range from no discipline to termination or discharge from the department. Next slide, please. We want to point out a couple of things on the Brady alert system. The LASD continually works with the DA's office to ensure compliance with all Brady requests for information. The department works with the DA's office to provide information on recurrent witnesses through the Brady alert system, which is handled and maintained by the DA's office. Next slide, please. Regarding ORWITS, or the Officer and Recurrent Witness Information Tracking System, we want to point out that ORWITS is a DA's database that contains information on recurring witnesses that may be discoverable depending on the facts of the individual case. LASD serves the LADA's ORWITS letters to named personnel as necessary and needed, and when we get the notifications from the DA's office. This concludes the brief presentation on an overview on SB2, ORWITS, Brady, and we have a team of subject matter experts available in case the panel or the public has any questions. We have Sergeant Scott Meredith that's ready to answer questions on Senate Bill 2, Captain Ron Copperud from the Internal Affairs Bureau, Captain Katrina Kazimpanth, which can answer questions related to ICIB, and Lieutenant Jose Aguirre, who will be able to answer questions regarding Brady and ORWITS. And that concludes our presentation.
Thank you so much, Ernie. We really appreciate it. And you mentioned your interaction with the LA County District Attorney's Office and how they're the ones who make a lot of the ultimate decisions. So we have Diana Turan here from the DA's office. And Diana, I'm going to turn the floor over to you now.
Good morning, everyone. Thank you for having me. I am the director over JCID. JCID is the division that reviews most officer-involved shootings involving injuries for all agencies, all police agencies throughout the county. We also review in-custody deaths where a use of force may be the proximate cause of the death, and any investigations that are presented to us for possible criminal filing against peace officers or others involved in the justice system. The AG reviews fatal officer-involved shootings of unarmed individuals. And I believe that is as of July of last year or the year before. Additionally, I am also the supervisor over the Discovery Compliance Unit. The Discovery Compliance Unit houses the database that contains impeachment or potential impeachment on peace officer witnesses, probation officers, and other recurrent witnesses such as experts. I started my career in the LADA's office in 1988, was here for about 10 years, and then came back in January of 2021 under the current administration to assist with police accountability and discovery matters. Prior to returning, I had various positions involving oversight of the Sheriff's Department. As pertinent here to this presentation, I wanted to talk a little bit about our interaction with Post. We were contacted earlier this year by the Bureau Chief, Mike Radford, and he came down here with two other individuals from Post, and we had an in-person meeting where we talked about collaborating and sharing information. And since that time, we've been in contact on almost a daily basis. They personally contact me for any follow-up information they might need. And conversely, they send me all of the letters that indicate that a peace officer has been temporarily or permanently suspended. In addition, what came out of that meeting with Post was a request that we consider requesting from individuals who we prosecute a voluntary surrender of their certification. So since that time, we have been, we kind of have that additional condition as part of our plea negotiations in appropriate cases. And we have been successful at getting, I think, 3 to 5, I'm not sure, voluntary surrenders as part of plea negotiations. And it's also something that we will be requesting post jury trial or court trial. With respect to the Sheriff's Department, I'm the point person on most matters involving police accountability. Since Sheriff Luna was elected, I've been meeting with members of their command staff on a monthly basis and sometimes more often depending on the situation. As of April of this year, the Sheriff Department now provides us almost immediate notification of anyone in the Sheriff's Department who has been arrested. We are currently also in discussions about when they can provide us or what information they can provide us with respect to post notifications. We can't handle all the complaints, but certainly some of the other information that we believe is discoverable as impeachment information, we want to try to get as soon as possible. So with that, if anybody has any questions at the end, I'll be here and I'm happy to answer them.
Thank you, Diana, for providing the DA perspective regarding engagement with post. We're next on the agenda is Max Huntsman, our Inspector General. And Max, I know you have a lot of experience dealing with the department and post issues. So I'm going to turn it over to you.
I do, Sean, and you had invited folks to introduce themselves. I'll introduce myself by saying I'm a justice system involved individual, a term that activists like to use. They often request that members of the commission or people working for the county be justice system involved, a polite term of saying, you know, somebody said you were a criminal, maybe correctly. I wasn't such a person before I was the Inspector General, but then as Inspector General, the previous sheriff threatened me to try to get me to suppress information about law enforcement gangs, and then announced that I was under criminal investigation. That case is still live. He sent it up to the Attorney General's office, despite an absence of evidence, I believe, and I'm still a suspect. So I'm justice system involved for those who would like to have such people be involved in this, and it gives me a unique perspective, I think, which is that the pretty story you've just heard is not really how things are. We have a case of the fox guarding the hen house. SB2 on paper sounds good, but in practice, it doesn't work at all. And I'll give you a specific example, a set of specific examples related to law enforcement gangs. Part of SB2 includes the requirement that law enforcement cooperate in investigations of misconduct, as well as conduct their own. So right after the law went into effect in 2022, my office sent a letter to the Sheriff's Department and requested their cooperation. And that letter requested both confidential information and non-confidential information. We received no response, complete lack of cooperation. The county reported that to Post, and Post sent us a letter. As you saw on the chart there, 5% of their cases where there are complaints have been closed. We happen to hit the 5%. They sent us a letter saying, oh, well, the sheriff relied on legal advice. They provided no evidence to support that. I'm aware of no evidence to support it. The county council is required by law to give advice to the sheriff, and they advised him to comply with the requests and cooperate as the law provides. And yet he didn't, and Post has done nothing about it and closed the case. So that's an example of what happens when you are investigating law enforcement gangs or misconduct. When you're actually complaining about them, as in my case, where I got threatened and charged, or not charged, but investigated for a crime, the law enforcement response is swift and very different. Before I get to that, I'll give you an example of, again, people who complain about misconduct. We were told by LASD that in cooperation with the Inspector General's office, they're in 100% compliance with SB2. I don't think that's true. For one thing, we had to point out to them repeatedly that they weren't providing complaints of law enforcement participation in gangs within 10 days, and we gave them numerous examples. They have purported to change their policy on that, but they still refuse to report when a citizen says to them, that police officer is in a law enforcement gang. They don't report that. So I call that non-compliance. On the flip side, we have people who are complaining about law enforcement gangs themselves getting reported. And I'll give you an example. There's a deputy who was beaten by a group that the undersheriff has testified under oath is a law enforcement gang. We have attempted to conduct an investigation, the one that I mentioned that the sheriff's department refused to cooperate in, to find out if there's complete evidence of that. But there's a prima facie case for sure. That man's suing the county, and the county lawyers shared with the sheriff's department information about him in a deposition, claimed that he had admitted to committing perjury, to lying on multiple instances, doing a bunch of things. The sheriff's department reported that to Post, claimed very specific misconduct, and sent them a transcript that absolutely proved that the claim was false. So there's a false claim by LASD on this person's record that went up to Post. Post asked them questions. They provided answers that made it, again, very clear that the claim of an admission of perjury or falsehood was simply not held up by the evidence presented. And I think that's not amongst the 5% that are closed. I think that case is still live and has been actively pursued by the sheriff's department. And we've asked them to do something about it, and they have not, at least not something that, in collaboration with OIG, we believe solves the problem. That all ran through the Risk Management Bureau, which we have a representative of today. You sent out a flyer in advance that the captain of that bureau would be here presenting. The captain is not present. So I think, as a person in the public who wants to wonder whether or not SB2 took care of the problem of law enforcement misconduct, and we actually have a system to make sure that people are just decertified when they commit misconduct, I don't think anybody should be confident about that. Now it's early days, so there's a question of growing pains. When the Constitution was passed, it said all men were created equal, and the people who wrote it didn't mean that. And hundreds of years later, we've tried to make it actually do what it says. And I think SB2 in the long run will be a very positive way to force law enforcement to account for their own misconduct and correct things. But we're not anywhere near that yet. I have more comments to make on the Brady issue when appropriate. I think it suffers from the same problem of lack of investigation by LASD. The Banditos example, something that certainly should be in the database that Diana referred to regarding possible impeachment of witnesses. Been no investigation to identify all the members to make sure that database is complete. So I think, unfortunately, in reality, we do not have a decertification process. Thank you very much.
Wow, thank you, Max, for that, providing that much needed perspective. Really wanted to have different points of view represented on this panel. And I appreciate your comments. We've heard from many panelists from the county or affiliated with government. We always, the COC always likes to have community voices. And to that end, we have Myra Joaquin from the ACLU who's going to weigh in. So please take the floor.
Good morning, and thank you so much for having me and inviting the ACLU to speak and comment on SB2's implementation and specifically LASD compliance. I'm Myra Joaquin. I'm a staff attorney at the ACLU Foundation of Southern California. ACLU SoCal has been actively involved in advocating for greater civilian oversight in LA County and throughout California, and also accountability of the sheriff and LASD. Through Cal Action, ACLU was a sponsor of SB2 and to date continues to monitor implementation of the bill and local law agency compliance. Next slide, please. Thank you. I'd like to start first by just sharing a brief overview of the impetus behind SB2. SB2 was a coalition-led bill that established a statewide process for automatically decertifying officers who have engaged in serious misconduct, including but not limited to dishonesty, abuse of power, physical abuse, sexual assault, any excessive or unreasonable use of force, and participation in a law enforcement gang. Through SB2, California must create a process to remove abusive officers from the streets to protect those who are targeted by police violence. This specifically aims to protect Black people, Indigenous people, people of color, LGBTQIA individuals, and those with disabilities who we know are often those who suffer the most at the hands of abusive police officers. SB2 has created the new accountability, through SB2, we've now created a new accountability division to independently investigate allegations of serious misconduct. It has also created a civilian-led advisory board that will review the investigations of the accountability division. And for those who may be interested in learning more, there are spots still available for participating in this civilian-led advisory board who can submit applications to join that board. And then through SB2, we also expect that POST will be filling in any gaps that local law agency investigations and will hold agencies accountable whenever they are not complying with SB2. Next slide. I'd like to speak about the process with SB2 thus far and some of the issues that we have been hearing from community members and from partners. And I do appreciate the extensive overview that has been provided thus far by other members of POST with regards to the specific steps that the agency takes. There are a couple of issues that have come up since SB2's implementation and the process that there is currently for decertifying officers. Those issues relate to trust from the community and SB2 and local agency compliance. It also concerns how to go about holding agencies accountable whenever they fail to meet any specific requirements of SB2, and also questions around the statute of limitations that are applicable for SB2. So one of the questions that we've been hearing is how are impacted communities supposed to trust local law enforcement, local police departments to follow SB2's law on reporting allegations of misconduct to POST within 10 days. Some community members believe that if police department is corrupt or if they are involved in the misconduct, that they will not follow the SB2 law. And so how will POST specifically hold those agencies that do not comply within that 10-day accountable? We would like to urge POST to ensure that you are reviewing agency compliance with that 10-day deadline, and also to assess for penalties that can be imposed if the agency fails to meet that deadline, so that there can be community trust created, and so that people feel comfortable knowing that local agencies are complying with the 10 days and that POST is holding such agencies accountable. Additionally, other questions that have come up relate to what happens when the complaint is first filed with POST. We understand that POST has a process where local law agencies are conducting the investigation first. However, there are concerns that there may be issues with the underlying law agency investigations. For instance, there may be instances where the local law agency investigation is insufficient. For example, if the local law agency is not speaking with relevant witnesses, not reviewing any video evidence that may be available, or if there are claims where the misconduct is retaliatory in nature. And so we urge for POST to be following up in such investigations, even when those investigations are first coming to POST, regardless of whether the agency, local underlying agency has reviewed, and especially wherever there may be examples of egregious misconduct that have occurred and the local law agency conducts an insufficient investigation. Another issue that is also coming up and that we urge POST to engage in is to also conduct investigations even when it receives information outside of the statute of limitations for discipline. This may occur where the agency, because it has already passed the timeline, no longer believes that there are any obligations or incentives to conduct the additional investigations. And so we ask that POST identify ways to direct the agency to follow up on those investigations and to investigate any complaints that come to the agency to POST directly. And I'd like to turn next to the next slide, please. I do appreciate the earlier information with regards to how many investigations LASD has reviewed and its interest in ensuring compliance by the end of this year. The information on the slide is based on information as of last week. So since then, there have been 3 more LASD officers that have joined the current decertification list that's available online. But I'd like to note that for now, there are 6 officers in LASD who are ineligible pursuant to Government Code 1029. Those are individuals who have been convicted of felonies. There are also several individuals who are under temporary suspension. 5 officers who are under temporary suspension for egregious or repeated acts that violate the law. 3 officers now that are in temporary suspension for physical abuse or excessive or unreasonable use of force. 2 officers in total who are in temporary suspension for dishonesty. One of those officers was also involved in excessive or unreasonable use of force. And 3 officers in total who are under temporary suspension for sexual assault. As others have said previously, SB2 was created so that individuals could be decertified. And so this temporary suspension that several officers in LASD are under does raise questions about the ultimate outcome of those investigations and whether they will be truly decertified, as was the aim of SB2. Next slide. So what's missing from the data? And again, because this is based on data from last week, there are now 6 officers who engaged in egregious acts to violate the law and 3 officers that are under temporary suspension for sexual assault. So there are more, and the bars are slightly longer for some of these categories. However, there's still clear categories that involve officers who have not been decertified in LASD and whom we believe should be decertified for those specific categories. So for example, one clear category where no officer has been decertified yet is participation in a law enforcement gang. There's also no officers who have been decertified for categories such as abuse of power, even though it's our understanding from various reports and other media reports and sources that have been issued that there are many officers who have engaged in this type of misconduct and who should be decertified under SB2. Next slide, please. This here you'll see the extensive list of deputy gangs that we are aware of exist in LASD. For over 50 years, deputy gangs have occupied stations in low-income Black and Brown communities throughout LA County. They have been confirmed to exist in East Los Angeles, Compton, South LA, and other regions. These are gang members who have targeted, framed, and killed people of color for prestige and for membership in these gangs. And there have been at least 19 fatal shootings that have involved suspected deputy gang members, some of whom were purportedly seeking to kill individuals to chase ink. Now, despite the numerous abuses on people of color here in LA, there are no officers yet who have been decertified under deputy gang categories. There also have been no officers that we are aware of who have been decertified or are currently under investigation because of any harassment on families of victims who have been abused by deputy gangs. And so here are only 2 examples of families whom we are aware of who have suffered from extensive harassment at the hands of deputy officers because of their relatives who were killed. And so there's still a lot of work that needs to be done to ensure that LASD is fully compliant and investigating individuals who should be decertified under SB2. And we're hopeful to be able to work with Post and others on this panel and members of the public to ensure that these individuals are reported and so that their complaints can be investigated and so that SB2 lives up to its promise of actually ensuring that no more abusive cops are on the streets. Next slide. And I'd like to end with just some resources for folks who are attending. If you're interested in submitting a complaint to Post, there is an online form as well as a paper copy. And there is an upcoming Post meeting in LA where members of the public are able to attend and provide public comments. That meeting is scheduled for September 21st. And you can learn more information about that upcoming meeting on that link. That concludes my presentation for now. Thank you.
Thank you, Myra. So we've had many different views of post and post compliance with the new decertification laws, and that's exactly what we wanted. So I want to thank our panelists for weighing in and saying what you really think, even when you all disagreed. And one thing that I wanted, we're going to take questions. I wanted to ask a few on behalf of the Civilian Oversight Commission, because we wrestle with these issues. And then we're going to open it up for public comment, because I know many members of the public are really interested in decertification and Brady and all the other issues that we have brought up. But since we have our friends from Post here, can I ask, does post decertification in the end rely on, does it require you all to rely on the internal LASD investigation of serious misconduct? Because as someone who has experience with those internal investigations, I think it is very hard for the department, and probably any department, to investigate itself.
Thank you, Commissioner, for that question. So we typically receive our reports as outlined in the law from the law enforcement agency, but we also take in public complaints. However, I think this speaks to something that you just heard previously from the ACLU, and that is there are times when Post will receive an internal affairs investigation that is incomplete. And we have had to conduct our own investigations upon receiving reports from law enforcement agencies, because there are gaps in the information that we receive. And our threshold by which we can take decertification action is clear and convincing evidence, which is beyond that for any law enforcement agency or employer to take employment action. So to answer your question, while we don't go in and spot check, if you will, we do respond to complaints from the public, and we do complete investigations if we receive an incomplete IA from a law enforcement agency. However, the only way Post knows about complaints or reports of serious misconduct is if the public does complain directly to Post, or if we receive a report from a law enforcement agency regarding some form of serious misconduct.
And I would also like to add, if I may, not only when there are gaps, but we've had one recent investigation that we conducted because we didn't want the department doing it. We felt that there's a conflict, or that might not be handled properly. So we handled that investigation and took the action independently. So we do that on occasion when necessary.
Okay. Max, you have your hand up. It sounds like maybe you have your own perspective here.
Well, I just want to point out what we were showing a slideshow from Post that I think said they've gotten 60 complaints of law enforcement gangs. I would assume that some or all of those are from Los Angeles County. In Los Angeles County, the number of internal affairs investigations or ICIB investigations or any other investigation within the Sheriff's Department in which they've identified every member of a particular group that is alleged to be a law enforcement gang, something that is an absolutely necessary investigative step, because the law provides that if you discriminate, you violate federal rules regarding employment based on race or gender. That's baked into the law. It's from the federal rules. Then you're a law enforcement gang. So again, on its face, the banditos and the executioners and some of the other groups appear to discriminate. We're not aware of any African American or female members of the banditos. That's what we have tried to investigate. The Sheriff's Department has never done that about any purported law enforcement gang to this day. And so if indeed Post were completing investigations because the agency wasn't doing it, they would have done that. And I believe the number of times Post has done that is 0. So I think, I'm not saying what they're saying isn't correct from their perspective, but for members of the audience who are wondering, again, if, as you say, Sean, it's difficult for law enforcement to investigate itself, and I include Post in the category of law enforcement, like the Med Board or the State Bar, they're an industry state group. They're not conducting thorough investigations, as far as I know, by that standard.
Well, can we have someone from the sheriff's department weigh in? Are you all investigating whether deputies are affiliated with a law enforcement gang? I mean, the statute has been around for a while now. And my impression is that those questions are not being asked with respect to police shootings or testifying witnesses in criminal trials, but maybe I'm wrong. So can someone from the department illuminate what is being done to investigate if people are members of illegal law enforcement gangs?
Good morning, Chair Kennedy. It's Ron Copperwood at Internal Affairs Bureau, and to the panel, thank you. I really appreciate participating this morning. And so to answer your question on the way Internal Affairs Bureau has handled these cases, whether it's misconduct to Inspector General Huntsman's point or the shootings, is that yes, we do look into that that information. However, the way that we've been handling it historically is if it comes to us directly within the case at hand. So I think the discussion, and correct me if I'm wrong, Inspector Huntsman, is that, you know, to your point, that the information is out there in the public and in oversight, and you believe or others believe that this should be then automatically incorporated to the investigations. But the way that we're handling it.
Well, I correct you if you're wrong. I'm not talking about information in the public. I'm talking about information in your
No,
file.
I'm sorry. I agree that information that the department has, let's say, but not necessarily in the case at hand. So, for instance, if
No,
there's a
I'm
shooting,
talking about in the case at hand. I'm
Okay.
talking about a case that gets referred to you in which it is alleged that a deputy is a member of a law enforcement gang, which has happened numerous times in LASD and in current cases. I am suggesting that it is not a complete investigation if you do not identify all the members of the alleged group so that you can assess whether or not it violates the law enforcement gang rules. You recently took action against a couple deputies under the policy that hasn't been updated to comply with the law. But as far as I know, you did not identify the members of the group to find out if it discriminates based on race or gender. It hasn't happened with the Banditos, hasn't happened with any of them. These are specific allegations that IA and ICIB were aware of, and that investigative step was not taken. I'm not talking about, oh, some captain out somewhere is aware of something.
I understand your point. The what I'm getting at was pertaining to the shootings. If there was a question, I guess, from Chair Kennedy, that you know, do we automatically ask questions regarding deputy gang association or affiliation, et cetera, with shootings, for instance? No. If we had the information specifically with that incident, then yes, we would. However, we don't do it by a matter of automatic, you know, course in the investigation. If that's clear. When it
Okay,
comes
but you
to
asked the question about the IA cases, and I just went into great detail about what I think is missing in your investigations. Am I mistaken about that? Is it actually the case that when an allegation of gang misconduct is made, that the sheriff's department is not identifying all the members of the alleged group in order to see if it violates 13670? Isn't that how it is?
Sir, respectfully, I know we're not going to agree necessarily on this point, but if I could
I'm
answer.
asking a factual question. I'm not asking if you think that's an appropriate investigative step. I'm asking you, do you do that?
So it looks like you want to answer, Ronald. Go ahead. Do you have any answer?
Yes, I mean, I've been working closely with the Inspector General staff about, you know, much of these, you know, these questions and these instances, and have had meetings with them about these cases. And the investigative steps have changed over time. I mean, we've discussed the fact that as the ACLU representative pointed out with all of these cases and lists several of these cases and subgroups over the years. 50 years, I think, was pointed out of subgroup and deputy gang, information on the department. This stuff has been changing over time, and we now have the Office of Constitutional Policing that was opened and stated by the sheriff. And as Inspector Huntsman pointed out, there is a policy, as my understanding as well, although I haven't seen it, that is in draft that we are going to come out supposedly to be in line with the law. And us at Internal Affairs Bureau, we work to the policy. So that's this has been changing over time. I agree with that.
Okay, I really appreciate the discussion. I want to ask our friend Diana Turan from the DA's office. Independent of post decertification, of course, the prosecution has constitutional obligations to warn accused people that prosecution witnesses have areas of misconduct that could impeach their credibility as witnesses. Now, to me, this seems like being a member of an illegal law enforcement gang would fit that bill. What, if anything, is the district attorney doing to ensure that its deputy witnesses that testify in criminal trials, either as investigating officers or gang experts, is anything being done to ensure that we're warning people that the deputies testifying in their trials are affiliated with an illegal law enforcement gang?
The short answer, I believe, is yes, but it's very complicated. I think the DA's office created a database back in, I want to say 2002. So it's been around for over 20 years. And that database has evolved over time. When I was with the doing oversight of the Sheriff's Department, I think about 10 years ago, and I had access to their internal databases, I saw that there were about 300 individuals that had founded investigations for dishonesty, for unreasonable force, for other misconduct that I felt was impeachment information that should be provided to the prosecutor as soon as possible so that the prosecution could provide that information to the defense. At the time, there were deputy gangs, I knew about them, but it wasn't part of the 300. So if we were to expand to that, it would be more than that. At that time, I personally went to the DA's office with the sheriff's permission and said, hey, we've got this list of about 300 people. We'd like to provide it to you so that you can provide that information to the defense. We were told at that time that it would be unlawful for us to provide that information, that list, to the DA's office. Thereafter, there was some litigation that went all the way up to the California Supreme Court. And the California Supreme Court held that it would be appropriate to provide the DA's office with a list of individuals with potential Brady information, such as founded investigations for misconduct involving moral turpitude. So after that case came down, we sent letters to all the individuals that would have been implicated, and the union got involved and got an injunction and prevented us from providing that list to the DA's office. Thereafter, there was additional litigation, and the California Supreme Court held that an agency could, if they wanted to, provide DA's offices with a list, but only on pending cases and not post-conviction cases, which in my view is incorrect. I think we have Brady obligations even in post-conviction cases. So I say this by way of background, that is kind of a Brady list. Then when I came over to the DA's office, part of the reason the DA wanted me here is to try to change our internal system and what we provide. So within a month of being here, we sent a letter to every single police chief and the sheriff saying, hey, we would like you to provide us with a list of all individuals who have founded investigations for these types of violations. And that caused a huge stir in the law enforcement community.
Can I ask why? Can I ask why? I mean, that sounds like the law.
Well, because the case, and it's I think it's ALADS versus Superior Court. I'm not sure what I don't have it off the top of my head, but the case said in pending cases, right? So the argument was, unless the case is pending, we don't have to tell you about, we don't have to provide you that name. So while some agencies did comply and gave us a list, very few agencies, for the most part, what we were able to negotiate with the law enforcement agencies is that on a monthly basis, we send each and every law enforcement agency in LA County a list of pending cases. And then they let us know if any of those potential witnesses in those pending cases have potential Brady in their personnel file. If they do, we document that information and provide it to the defense, and they will file a pitches motion, which is a motion in the court with the court to try to get personnel records, or we might also file it to get the information. But law enforcement personnel records are confidential for the most part, because now we have SB 1421 and SB 16. So concurrently with those efforts, we started sending PRAs to all law enforcement agencies saying, okay, give us all your 1421 information. And every time we get that, we do upload it to our system. I wouldn't say we have a Brady list, but we have a discovery compliance system. And it's still evolving, and we're about to make a very big change to it, or what I think of as a significant change. And that is, we have split it up into impeachment and potential impeachment information. So say, for example, an individual is involved in an officer-involved shooting, responds to an armed robbery. The armed robber shoots at the officer, and the officer shoots back. And everybody agrees, you know, it was justified and not unlawful for the officer to do that. Even though it's not in and of itself impeachment information, it might be potential impeachment information if that officer has a whole bunch of different shootings, or if there's something about the investigation that we received that might be relevant to a particular defendant's case. So we put it in what was referred earlier as Orwitz, but we instruct our deputies for most of the Orwitz entries, look at the information and decide whether it's relevant and potentially impeaching in your particular case. What we're about to do is just instruct our deputies to err on the side of caution, and anything that is in our database should be turned over, whether it's potentially impeaching in a particular case or just very obviously impeaching. So all the information that we've gathered with respect to deputy gangs is in our database, but the information, in order to get into our database, has to have, it can't just be rumor or speculation. We get complaints from the public, from incarcerated or formerly incarcerated individuals, from family members, from defense attorneys, from law enforcement. We get thousands of complaints, and we look into them and try to only enter that information that has some basis, some substantiation, that's not just based on allegations.
But Diana, how do you move beyond rumor and speculation if neither the DA nor the sheriff's department will actually investigate that? It's just an allegation from the public. If they won't go and investigate it, it will always be rumor and speculation.
Well, sometimes we do. It just depends on the case. And fortunately, with body-worn cameras now and a lot of surveillance video, we have been able to substantiate some of the allegations. We just received one recently where the allegation was that there was pressure on a victim to identify by a police officer, and we were able to track down body-worn camera footage that shows the interaction. So, you know, so it just kind of depends. Sometimes we are provided depositions from civil cases. So it just depends. It's not like we need a whole lot of substantiation, but we do get some allegations, some complaints that are really, we can't seem to substantiate at all. So
I got you. I really appreciate your thorough answer. I want to take questions from the public, so I'm going to end with one last question for Post. This commission, the Civilian Oversight Commission, just spent the last year investigating deputy gangs in the LASD and issued a report on it. And in the course of that year-long investigation, we held hearings with sworn testimony, and over again, members of the department refused to appear, even if they'd been subpoenaed, high-level members too. And my question is that a failure to cooperate that would constitute a post violation?
Thank you, Commissioner. You know, it depends on the facts of the case. So the officers have a right to be represented by counsel in all of these matters. And counsel may advise their client to not answer specific questions based on incrimination or other pending legal matters that may be in the criminal system. So Post cannot then, use that as a means by which to decertify the officer for failure to cooperate if they are legally advised to not answer questions based on the protection of their right to due process and their right to representation. So I think that's where we're maybe the rubber's hitting the road here, that the officer with the agency can be, have a Libarger or admonishment where the agency may be able to take disciplinary action from an employment perspective that cannot be then used against them in any criminal proceedings. So, Post is not part of the employment agency. And I know, there's going to be several questions around independent cases, which it's not advised that, Executive Director Manny Alvarez or I answer. For the fact that these cases, as more information may come to light, may come to Post, we don't want to compromise our ability to examine these cases fairly equitably and take into consideration any new information that can be forthcoming. So I won't answer questions regarding individual cases. It's not appropriate for me to do so. Thank you.
I totally respect that. I didn't intend to ask individually, but Anne Marie, I just want to make sure I'm clear. So if you can get a police union lawyer to tell you don't show up in response to your subpoena, then Post is not going to get involved, because that's what we're seeing.
Yeah, and I would say it depends on the particular advisement from counsel and the facts surrounding the case. So the same thing can be true for if we, which we have already, seek to interview an officer regarding a case that has come before Post, and the officer refuses to speak to us under the advice of legal counsel. That doesn't prohibit us from moving the case forward. That would become part of the case, that there was, no participation. However, the circumstances you're referring to was on advisement of an attorney and based on other things that were going on at the time. And these things all run through our legal department. So we have a chief legal counsel and a team of attorneys as well that advise us on at what point can Post perhaps use the failure to cooperate because there has been a deliberate act on the part of the officer to circumvent the investigation.
Well, I really appreciate your frankness. Danielle, I think we have questions from the public, and those are probably our most important questions. So can we move on to those?
Absolutely. As a reminder, if you're logged into WebEx to ask a question, please raise your hand. If you have called in, press *3 to get in queue to be unmuted. I'll unmute you when it's your turn so that you can ask your question. And if your question is for a specific panelist, please feel free to state that. To ask a question, you must be logged into WebEx or phoned into the meeting. If you're commenting on Facebook Live video, your question may be read out loud by the host. And before we begin, we will have a quick announcement in Spanish. So Daniel, if you could please go ahead.
Sure, thank you, Jennifer. Buenos días. Se ha iniciado la conferencia por WebEx y le gustaría hacer un comentario o pregunta sobre el tema. Por favor, oprima la imagen de la mano y alguien le ayudará. Si está escuchando la conferencia por teléfono y le gustaría hacer un comentario o pregunta, por favor, oprima la tecla de la estrella y el número 3 y alguien le ayudará cuando sea su turno. Si está viendo la conferencia en vivo por Facebook y ha escrito un comentario o pregunta, la coordinadora de la conferencia va a leer su comentario al grupo. Por fin, si su pregunta es para una panelista específico, por favor indique eso al comienzo de su pregunta. Gracias.
Thank you very
Jennifer.
much, Daniel. Yes, thank you. So Stephanie Vallejo, you will go first. We've sent an unmute request to you. Okay, it looks like you're unmuted. And before you begin, just as a reminder, this will not be timed because this is not public comment. These are questions for the panelists. So please go ahead, Stephanie. Stephanie, I see that you are unmuted, but I don't hear anything coming from your line. If you have any other applications open, such as Zoom or Microsoft Teams, those may be using your microphone. If you can close those applications and sending the unmute request. Yes, we do. Please go ahead.
Thank you. I want to start with the comment to Mr. Inspector Huntsman. I completely agree with you that we can't always trust the police to police themselves, not always. And with Post, the problem that I see with Post is that it hires mostly police officers to do its investigation, so that could be a conflict of interest. But my question is for Post. Does SB2 apply to only current police officers, or does it apply to retired police officers who can retire from one agency and then go work for another, or pending employment with another police agency or security department? And my second part to my question is, if SB2 or Post finds an investigation or conducts an investigation and it turns out that they get decertified, does that decertification carry over to any security credentials with the Bureau of Security and Investigative Services? Thank you.
No, go ahead.
No, please.
So to answer your question, I think you were asking about the law enforcement consultants that currently work at Post, correct?
I think your first question, ma'am,
No.
was whether it applies to both current and former peace officers, if we understood the question correctly, and it does apply to former peace officers that maintain certification with Post. So yes, they can be decertified after they have left service. I believe your second question was whether decertification impacts other clearances or other certification with agency or departments such as BSIS that licenses security guards. It does not. It only applies to peace officers for peace officer certification. Now, that doesn't prohibit them from taking some form of action if they wish at BSIS or other licensing agencies, but it does not apply.
Thank you very much for answering that. And next we will go to George Washington. An unmute request has been sent to you, George. If you can acknowledge that, please go ahead.
Can you guys hear me?
We do hear you. Yes, George.
Yeah, I wanted to ask if you're considering retiring and giving somebody else the opportunity to fix this issue.
And George, did you have a question for a specific panelist or?
Yeah, Diana Taran or Taran.
And what?
You said you have 10 years and you weren't with the impending cases, you weren't able to do anything because they were ahead of you.
No, so I'm sorry, the question is, would I consider retiring? Absolutely. I would love to retire and have somebody take over this position and try to do a better job. But I'm doing the best I can to move the ball forward, to be as transparent as possible, to get information in our database as quickly as possible, and to oversee JCIT in a manner that holds police accountable far more so than it has in the past. I think prior to DA Gascon coming in the prior 20 years, there had been one officer-involved shooting case that was filed. Since his administration came in, we've filed 6 officer-involved shootings. We've filed a total of, let's see, I think 84 cases involving misconduct of peace officers or other justice-involved individuals. The 84 total is just the cases. If you count individuals, it's far beyond that. So I am doing the best I can, but I would welcome being replaced by someone who might be able to do better.
Thank you very much for that answer. And next we'll go with Joanne Droshlin. You're unmuted. Please go ahead.
First, if I may, it's Johann Drolzagen. I'm actually the individual that created the online platform known as the Brady List, and my question is specifically for the prosecutor, the district attorney's office. Since Brady is both perpetual and retroactive, and it's required to be proactively disclosed, how does the prosecutor's office handle proactively disclosing all known high-value Brady material to pro se defendants?
Well, obviously what we try, it's much easier if there's an attorney. With the pro se individuals, especially when we have to go back to post-conviction cases, if they're in custody, we send the letter to the individual at his custodial address. If they're not in custody, we look up on our databases to see if we can get a current address for the individual and send them a letter indicating that someone in their case who was a potential witness has Brady material, and we generally don't provide the stack of Brady material. We'll provide just the allegation or the finding or the information, and go from there. But I'm sorry, I didn't catch, you said you created a Brady list for what?
Every law enforcement agency in the U.S.
Oh.
You'll find it at giglio-bradylist.com.
Oh, okay. Yeah, so that's what we do. The issue has also been, because of this this Orwitz versus Brady, potential impeachment versus definitely impeachment. It's been complicated, and we're having to go back because a lot of things that were designated Orwitz by the prior administration, we are finding are definitely Brady, including and specifically a lot of allegations of bias. So when we find that and we move it into Brady, then we do a look back, because we don't think someone from day 5 to day 10 became biased. We believe it might affect all prior cases. So we do a run of all prior cases where that individual was a potential witness, and we send letters to the attorneys and or the pro se defendants.
If I may, just to follow up with that, in other jurisdictions, we've had exceptional opportunities to actually do mass exonerations. The mass exonerations is a decision typically made by the court because of the number of cases affected by corrupt police officers or things that are obviously Brady material. And under US v. Able, your entire list of LASD that are deputies could result in tens of thousands of exonerations happening at one time. So does the district attorney, does George Gascon have a plan to handle the release of that information that will undoubtedly result in overturning of tens of thousands of cases simultaneously? Oh, and the cost of actually paying them for the wrongful convictions.
Well, I guess the quick answer is no. I'm unaware of Brady information affecting tens of thousands of cases. I think we have to look at each case. First of all, we can't just systemically exonerate people. We have to get permission from the court. We have to file documents in the court. Sometimes, no matter, say an individual we know is, has Brady information, but they didn't really play much of a role in the conviction, we have to take a look at that case and see what that individual's role is to see if that person was material. If, if that person was the only witness to whatever this individual was convicted of, then that's a different matter. So what we have done, like prior to coming back to the DA's office, I was with the public defender's office as their law enforcement accountability advisor. And what I would do is when we got Brady information, we would look at those cases where the person was a material witness, bring a stack of those cases to the DA's office and work together with them to dismiss that. The last time we did that was with respect to Torrance police officers that were involved in the exchange of racist texts, where we ended up dismissing at least 60 cases and probably more. We stopped counting after that. But again, we had to do a case-by-case analysis. We can't just because an officer, for instance, is caught lying today, it doesn't mean that he lied in every single one of his cases, and it doesn't mean he's material in every single one of his cases. So we have to look at it on a case-by-case basis. I had not heard of situations where there are mass exonerations.
Thank you very much for that answer, Diana. Thank you. The next question will come from Constantine Anthony. Please go ahead.
Hello, this is Mayor Anthony from the city of Burbank. I'm also a candidate for LA County Supervisor. My question to the panel is this. We know that SB2, although on its surface sounded great and covered a lot of things, but the execution on the ground level has been lacking. So the question I'm asking is this body prepared to make recommendations, policy recommendations to the DA, to the sheriff, to the board of supervisors, or even to the state legislature and the governor to either refine SB2 or put in policies that fix the shortcomings? Are there any policy recommendations directly to those executive bodies?
Thank you for that, Mayor Anthony. I'm not sure if any of the panelists would like to jump in. Please go ahead, Max, Inspector General.
This body, if you mean the Civilian Oversight Commission, has made a lot of recommendations that are adjacent to SB2. SB2 is kind of new on the block, so I don't know if they've had an official SB2 recommendation, but they've made many recommendations. My office has written many reports with recommendations relating to the discipline system that have yet to be implemented by LASD, and I think fall within the category of the things you're talking about. Specifically on SB2, we have lots of recommendations we could make on how it could be improved. But ultimately, SB2 was a kind and generous gift from the legislature, as was the anti-gang statute. And we don't usually get that kind of support out of the legislature because of the powerful societal influences, pro-law enforcement, anti-law enforcement, the way people view those things often gets in the way of intelligent reform. So we don't usually go running to the legislature. The ACLU is present, and they sometimes lobby on behalf of particular changes, but we report what works and what doesn't work in much the way we're doing today. In my reports, I've reported on, and we've demonstrated what happens when the Inspector General's office attempts to investigate misconduct. And you've just heard about it. You've heard about what Post does about it. You've heard about what the department does about it. And although you might not have heard about it today, in court, the union brought an injunction and said, before you enforce state law, you've got to negotiate with us because it might have an impact on our working conditions. So yeah, we would welcome fine-tuning of SB2, but that's not directly within our job description, I guess. But we hope always that people in power will read our reports and take pity upon us.
Myra, do you have any answer to the caller?
I echo what Inspector Huntsman said. We have been, as I shared, monitoring what compliance, and we are concerned about the fact that there are many forms of decertification categories there where officers are not being decertified yet, especially given the extensive list of individuals who we know may be suspected deputy gang members, and also others who have engaged in bias and attacks against family members. And we are also engaging in advocacy to ensure that there aren't any undermining of SB2. We know that there have been attempts to try to change, for example, the transparency that comes out of SB2 and how much information is available to the public. And so we'll continue to engage in that and advocate against any policies that would weaken SB2 as implemented, and hopefully continue to actually strengthen SB2 so that officer decertification is possible, and so that we see more faster processing actually of the investigations that are going to post, especially given that they're, as the agency indicated earlier, they have received investigations related to deputy gangs, but for now we have not seen anyone decertified yet.
Thank you.
Thank you. And next we'll take CJ Nord. I am acknowledging that it's 10:30, which is when we said the conference will be over. So if any of the panelists do need to hop off, we completely understand. But Chair Kennedy, is it okay if we take just 3 more questions?
Yes, if
short.
people need to leave though, they ought to leave, but you know, we can field as many questions as we can. Go ahead.
Okay, go ahead, CJ.
Thank you. My comment is regarding the use of ethnic images for shooting targets, such as what we have all seen news reports of recently, where various police departments have been using shooting targets which look like Black men. I am pursuing legislation which would make the sale, use, and manufacture of shooting targets which look like specific ethnic groups illegal in the state of California.
Thank you for that, CJ. And I just want to make sure that as you wrap up your comment, that you do relate it to a question for one of the panelists related to police officer decertification.
You know, I actually just wanted to ask if the panel would consider action on the item prior to legislation. So it is unrelated to decertification.
Okay, I encourage you to send an email to the commission at cocnotify@coc.lacounty.gov.
Okay.
And we will move to the next question, hopefully related to police officer decertification for one of the panelists. Andrew James White, please go ahead. Andrew, I see that you're unmuted.
Yes.
Do you have a question for the panelist?
I have a question for post. Let's say here that somebody is running an open complaint through utilizing an administrative resource and in an administrative hearing process through Ralph Brown Act or Article 1, Section 3, in conjunction with a complaint from the DPA. Okay, so there's DPA and there's administrative hearing being involved revolving mostly around SB 16, SB 1421, PCA 32.5, Article 1, Section 3. How likely is post to get involved if I file another complaint in conjunction with all what has just been spoken with post to get involved with the administrative hearing? How likely are they? I'm trying to figure out the order of operations here. How likely is post to get involved at this point in the process?
Thank you, Andrew, for that question. Post, if you have any comments on when you're likely to get involved in complaints.
We do. I think what you're referring to is a DPA hearing, so a personnel hearing that the agency is already taking some action, and there's a personnel hearing that's pending. Your question was, if you filed a complaint with post, would we pursue reviewing that complaint and conducting an investigation while there's a pending outcome of a DPA hearing? Is that your question?
Yes, that's how I interpreted it.
So we're not bound to what we would consider toll our cases for personnel actions, nor would we. And we're not held or bound to any settlements on the part of the department in any kind of personnel or administrative action on the part of the agency itself. So post process is separate from what an agency would do with regard to an employment action.
Wonderful. Thank you for that, Anne Marie. And our last question will come from Stephanie Luna. Stephanie, the request has been sent for you to unmute. Please go ahead. And I'm not hearing you, Stephanie. Oh, we do now. Please go ahead.
Okay, yeah, so I have a lot of questions. I'm gonna try to narrow it down to just a couple for the moment. One of my main questions is for the post decertification. I heard someone say that you've used depositions from civil cases. I'm not sure who made that comment, but I'm curious because in my nephew's civil trial, we have the two deputies that are alleged deputy gang members that under oath stated that both of them have had a total of 50 plus incidents of misconduct. And I'm wondering if that qualifies for means of decertification. And that's aside from the harassment, intimidation, and, you know, other factors that my family has faced.
Thank you,
kind
Stephanie.
of going
So-
through the process of litigation. So that's pretty much my question is, do depositions classify as a document that can be used for decertification?
Thank you, Stephanie.
Hi, thank you. Yes, depositions do. We look at transcripts of interviews, depositions, anything that would be considered perhaps evidence to speak to officer statements in response to any of the 9 acts of serious misconduct. So as long as they fell into one of the 9 acts of serious misconduct, that post can take disciplinary action as a result of, then yes, depositions could be included as evidentiary.
Wonderful. Thank you for that answer. And Chair Kennedy, that does conclude all of the public questions for today.
Well, I want to thank our panelists for sharing their experiences with the new decertification law. Sounds like we have a long way to go. And I want to especially thank the community members for participating in this important conversation. The conversation will continue at the Civilian Oversight Commission meetings in the future. We hope you will join us at our next upcoming meeting on September 21st at 9 a.m. We don't have a location yet, but it will be posted as soon as we obtain a location for that meeting. Panelists, thank you for giving us your time. We really appreciate it. And this concludes our conference.